distinguished guests, Assalamu alaikum. I just want to make a couple of comments. I've gone through the report, and so my perspective would be how does the judiciary, or at least a judge at the Supreme Court, is looking at it, and some comments. I understand that Mr. Mahmood has just mentioned that this is in the process of discussion and deliberation, and it's kind of fluid. So perhaps some of the suggestions, or some of the interventions that I propose to make could be considered at some stage. Even though I fully agree with the policy, I agree with the emphasis that it lays on reducing the punitive measures, the overcrowding of the prisons part, and moving on to rehabilitation and public health issues. Fundamentally, nobody can disagree with that. But let me just take you to our landscape and make a distinction here. This is very important. Now, in our set of, when you look at our narcotics law, we have three categories of people that we need to understand. I take it that this report is only dealing with one category of people. There are three categories: are the actual suppliers and producers of narcotics, the big barons who are making the supplies. The other is the courier, or person who's transporting this, or the distributor. That's the middleman who's doing this. And the third is the user, the actual purchaser, the actual victim. And I think the focus of the report is actually more on that victim and user, and I fully support that in that context. However, it does not really, and I want to understand, and I was discussing this with Mrs. Zaved earlier, that perhaps we want to know that the real people, the people who are actually supplying and producing, we never reach them. The people who actually come to court, and the cases that reach the Supreme Court at least, and Mr. Tarar, who is an expert criminal lawyer himself, would vouch for that, that it is actually the distributors and the couriers, the cases of which come to us in the court. So users, because of the small quantity, get sorted in the trial court, and I'm sure they get relief, and they never really get to the Supreme Court that much. So the two main areas of the suppliers and the distributors and the couriers or the distributors are not in the picture, and they are the ones who need to be, we need to consider. Most of the case law that's been developed is around the courier and the suppliers and the transporters. So the report, as I said, focuses on user, to my understanding of the report. However, the law that we have in Pakistan covers all of them. It does not make a major distinction between a user and a distributor and a supplier. It is a quantity-based law that sort of moves in that direction. But there is, because why I say that is because the law talks about possession of the narcotics. And it doesn't, the word user isn't really used in the law. It's actually the possession of it. And that possession could be with anybody. Could also be with a user, could be a very small quantity, and he gets kind of the same treatment as all the others, which is rather unfair. But the law also talks about treatment and rehabilitation of narcotic addicts, you see. So I think there is a bit of a soft corner within the law regarding the users we're talking about under the report. That's very important. I want to flag that. That's in the preamble itself, which says regulate the treatment and rehabilitation of narcotic addicts. Then we go on and we have within the law a provision which is section 53 and 54, which talk about setting up centers, rehabilitation centers, and the law minister is here, and I'll urge him that unless we have that ecosystem going, we can't really put this report to action. We can't even adjudicate in that direction because we do not have the centers to send them to. So I think these centers, which I hear, some of them have been established here or there, but there are no established centers for these people. Where do we send them? And I hear, and out of practice, let me tell you that at certain level, a lot of parents would want, talk about villages, and I hear this from, it's hearsay, but I understand this might be true. And Mr. Tarar, who belongs to has a rustic background, probably would also support me in this, that a lot of parents would want these drug abusers or users to be sent to prison so that they get reformed. So they're actually sending them to prison to get reformed. Please try to understand and appreciate that. Rather than sending them to facilities which could actually work on them and reform them, they would say, okay, let them go in for a small drug abuse to the prison, and maybe because they won't get anything in there, they get reformed. So that's the state of affairs. That sort of underlines the fact that we must have these centers working, and I request the Honorable Minister to consider this aspect of the matter. But my inputs are, and I would like to also refer, as far as the user is concerned, as I said, we fully support the report to the extent of the user, And one case which has probably gone untouched and nobody's really talked about it, I haven't seen it in the report. This is Sabir Masi case, which is PLD 2006 Karachi 552. In my research, I pulled it out, and I think it's an important case because, as I said, these cases regarding users about small quantities hardly get to the Supreme Court or to the High Court. But this case is rather interesting, and I just want to paraphrase some of it from. So, accused was a physically disabled person as his right leg was cut. Looking to the condition of accused and taking into consideration the fact that he was a beggar and not a person who was involved in corrupting the society by supplying narcotic substances, and in all probability, he must be user of the drug as normally beggars become, and thus would be a victim himself. For the first time, they recognize that. Such person needed sympathetic treatment because there were no social services in the country, either in the public sector or private sector, for rehabilitation. This is as late as the 2006 court recognizing there isn't any center. What do we do with this guy? He's a user. So, they reduced the sentence. There was a sentence given, but they reduced it, trying to say that the court appreciates the fact, quite in line with your report, that users ought to be treated differently. But as I said, an ecosystem ought to be constructed to really actualize the thought. On the other side, I just want to, when you talk about this restorative justice concept of how to, reform them and how to put things in order, let me also say that we need to bring back in the law, if you see, we have now a sentencing policy, even though I think the court could not have possibly laid down a sentencing policy, but glad that it turned out well. And now we have a legislative sentencing policy. This is required in many other laws also. Extremely essential thing, and I once again urge the law minister to look at sentencing policy generically for all sorts of criminal offenses. This is a concept that's really missing and lagging in our country, and that has to be done, but it's a welcome addition to our narcotics law that we have a sentencing policy. So that does take care of many problems. However, we need to understand that we need to bring back the probation law into this. The law takes out probation. So when you talk about users, I think probation law does wonderful work for them. So under the probation law, there could be conviction, but they could be put on some probation rather than sending them to prison. That's one cut. The other could be the same probation law, which is the Probation Offender Ordinance 1960, also talks about conditional discharge. A person could be sent out, without any liability, and could be sent out under some certain conditions. Once again, not sending the person to prison, but sending them out. But this window has been shut in the recent amendment, and I urge the law minister to please reconsider for smaller offenses to bring back the probation concept into it. The third concept within the probation is admonition. There is no conviction, there is a total discharge, but there is with slight admonition. So the admonition ought to be there. This entire concept is gone, and I think it fits in very well with the report that we're talking about, and I think we should bring these three categories of probation into the concept and look into it. I also want to highlight that the entire law hinges on the report of the public analyst, and the Supreme Court has gone ahead. The entire case, the only evidence in the narcotics case is the analyst report. And Supreme Court has gone ahead and developed protocols, and we've stressed that the protocols ought to be followed. We have public analysts in some of the provinces who would probably look at the drug or the narcotics and say, we think it is this, which is not really acceptable. And that is happening in certain provinces where the facilities aren't there. So the Supreme Court went ahead and stressed that the protocols and testing a drug ought to be very important, which also is in line with what we're trying to talk about. So these are some of the things, but at the end I would like to say that probation concept needs to be brought in. Sentencing is very good that has come in. I think let that be a starter for all the other criminal laws, and we need to bring that in. And otherwise, I think it's wonderful that this is happening. I'm so happy that the experts from Sri Lanka and Mr. Mahmood are here. I've already invited them to the Supreme Court to come and sort of enlighten us more on how to proceed further. Very excited about meeting them later on, and I'm very happy that this report has come about, bringing in this debate and dialogue, which wasn't really there earlier. Thank you so much for inviting me. Thank you.